Okay, good evening, everyone. Tonight we're joined by Richard Silver, Senior Partner of Silver Shemmings Ash, and we're going to be talking about compensation events. As always, if you could put your questions in the Q&A box in the bottom toolbar, and Richard will answer those at the end of the presentation. And if there's something specific you'd like to ask Richard, but you don't necessarily want to raise it during the presentation, please feel free to email him on richardsilver@silverllp.com. He's always happy to help. So without any further ado, Richard, I shall hand over to you.
Thank you, Julie. Good evening, all. As Julie has kindly said, we're going to be looking at compensation events under the NEC form. We're then going to have a look at relevant events and matters under the JCT form and to consider the difference between the two. You'll see the slide in front of you, the proposed agenda. The starting point is what actually is a compensation event. Now, NEC took a very novel approach, and in their forms of contract, what we have is an amalgamation of what is extensions of time, loss and expense, and the value of variations, which are generally dealt with separately under other forms, but under the NEC are amalgamated. So effectively, what is a compensation event? It is an event which is likely to either have caused delay or increased cost. And as a consequence, the contractor is potentially entitled to either further time and/or further money. Now, I'm going to deal firstly with that issue of time. As you will all be aware, most contracts have a completion date. And if a contractor fails to complete by that completion date, there is generally a provision for liquidated damages. Under subcontracts, quite often, as opposed to liquidated damages, there is provision for general damages. The difference between general damages and liquidated damages is that liquidated is a genuine pre-estimate of the loss. So for example, it could be stated as 4,000 per week or part thereof. A contractor finishes 1 week late, you times it 1 week by £4,000 and you get the amount of damages that can be withheld. General damages you have to prove, and that is far, far more difficult. If a hospital finishes late or a road, what's the loss? Very difficult to prove. And it's on that basis that many main contracts have liquidated damages. But ultimately, all contracts generally have, or all construction contracts have, a date for completion. Now, in order to keep that date for completion enforceable, you have to have provisions for extensions of time. The reason for that is if you do not provide for the extending of the date for completion, where the delay to completion has occurred because of a failure by the employer, time will be rendered at large. Equally, if there's liquidated damages, those damages will be rendered at large. In other words, the genuine pre-estimate stipulated sum will fall away and the employer will need to prove their loss. So where a contract is delayed and there is no provisions for extension of time, and the delay was caused by the employer, rather than having to complete by the date stipulated in the contract, the contractor has to complete within a reasonable period. And similarly, the liquidated damages will fall away and the employer will have to prove what their actual loss is. To overcome that, any event which is a breach by the employer, in other words, the employer is causing the delay, the contract needs to provide for extensions of time. And indeed, both the JCT and NEC do that. So for example, under the NEC, we have events for instructions and late access. Those are both failures by the employer. They both represent breaches which will cause the contractor to be delayed. To avoid time and damages being rendered at large, we have provision for extension of time. But at the NEC, we go further. Not only do we have the provision for extension of time, but we also have additional money, and the value if it's a variation, the valuation of that variation, all amalgamated. Now, what the NEC does is it basically limits what are the events for delay. And they list what are the events upon which the contractor can claim. And it even provides for flexibility in that you can add in Z clauses for other relevant events. And as I'm sure you're all aware, the NEC has 6 options, and there are different compensation events for each of the options. And what it's doing is it's putting down in the contract clear and specific provisions of how all these delay events and variation events and additional lost expense events are to be ascertained. And what it is also doing, it's excluding your common law rights. In other words, it is excluding a claim for breach and damages. That is not the case under the JCT. Your common law rights are retained. So the NEC provides for quite a lot of flexibility. What it is also trying to do is to allocate risk to the party best able to deal with that risk. And that's created by the flexibility of the form. What I've done here is listed some of the events that are cited as compensation events under the NEC. Anything that is a change, obviously it's coming from the employer, and as it's a change requested by the employer and it's likely either to cause delay or additional cost, it's a compensation event entitling the contractor to claim a compensation event, an extension of time and additional monies. Failure to provide access, again, is a failure by the employer. If there was no entitlement to an extension of time, time could be rendered at large. This contract refers to access, unlike under the JCT forms, which refers to possession. And when dealing with the access, it is as stated in the contract data or as shown on the latest accepted program. And that's one thing I would really emphasize under the NEC is the importance of the accepted program. Now, from my own experience, I find all too often on projects that I become involved in that there is no accepted program. And where I act for the employer, they explain the reason for the failure of a program is that the contractor has failed to provide one, either at all, or that the one that has been provided is woefully inadequate. When I act for the contractors, they often say that they've issued what they perceive to be a more than reasonable program, but the employer will never accept it. This creates quite a few problems because many of the provisions within the NEC are reliant upon there being an accepted program. So my advice to both employers, project managers and contractors is seek to ensure that there is an accepted program. Now, for those of you who might not be aware, under the NEC, there is an accepted program that is regularly updated. Now, the contract provides that within the contract data, there is a statement of how often the program is to be revised and reissued. There is then a requirement also to issue a revised program for each and every compensation event. And when the program is no longer reflecting what is actually going on. So as you can see, if you were really to follow the contract to the word, it is possible in the most complicated projects that you have an obligation to issue an accepted program or a program for acceptance on every day. Now, returning to the issue of access, it is important, particularly for the contractor, that he puts within that program when he requires access to the particular area. Because if that access fails to be given, that in itself is a compensation event. I think that's a useful thing to draw. Under this form of contract, it is a particular event that constitutes a compensation event. You don't necessarily have to show off and show that it causes a delay to the completion. What you have to do is to simply show that according to the accepted program, this was the date of the access. And as of today, I haven't got access, so therefore is a compensation event. What I then do is to issue a quotation for that compensation event. And as part of that quotation, I include a new program for acceptance. And what I show is what is the effect of this delayed access. And if I show that the date for completion is later than the previous program, and that is a reasonable assessment, that's my entitlement. It may prove to be completely wrong, but it is based upon forecast. And as those of you who deal more commonly with JCT will be aware, JCT, you have to prove your entitlement. It is quite different. Another compensation event, failure of the client to provide equipment, plant or materials. Within the contract, there is provision for the client to provide certain plant, equipment, materials. And if they're not supplied, obviously that will cause delay. Others that are referred to, interestingly, is exceptionally adverse weather conditions, which I'm going to turn to in a moment. One fundamental difference between JCT and NEC, as I said, is under the NEC, when assessing a compensation event, we deal with both time and cost. Under the JCT, the issues of relevant event and relevant matters are separated. So we have some events which entitle us to extension of time, but no money. Under the NEC, all events entitle us to money unless there are bespoke amendments. And one particular area which is relevant to that is exceptionally adverse weather conditions. So under a JCT form of contract, if we are delayed by exceptionally adverse weather conditions, I'm sure you're aware, we would be entitled to an extension of time, but no loss and expense. Under the NEC, we would be entitled to both time and money. Under the JCT, we have what are quite often referred to as neutral events, and that would include the exceptional adverse weather event. And what a neutral event is an event where, in effect, the risk is shared by the employer and the contractor. Now, the only events that can be neutral events are events that are not the responsibility of the employer. The whole idea is that if there is an event which causes delay, the question is who should take the risk? Exceptionally adverse weather conditions is an event for which the employer is clearly not responsible. But under the JCT, it was perceived to be fair and reasonable that the risk associated with the delay to the completion should be borne by the employer. And as a consequence, we have a provision for extension of time for the weather. By contrast, so far as the additional cost is concerned in relation to a delay caused by weather, JCT were of the view that that is a risk better borne by the contractor, and hence there is no relevant matter. Other events that are these neutral events are delays by statutory undertakers and antiquities and other similar activities. Under the relevant events under the JCT, I have again listed out here all the events that are included in this form. And you'll see that they are a mixture of delay events, which are events for which the employer is responsible, particularly the first two, variations and architect's instructions, and events which are seen as neutral events, including force majeure. I suppose I should add at this stage that there has been quite a lot of argument that the coronavirus would apply or be under force majeure. Now, force majeure is an act of God. It's something that neither party could necessarily have foreseen. And as a consequence, the contractor would be entitled to an extension of time, but not loss and expense. But do be aware, it is based upon the time the parties entered into the contract. So if you're going to enter into a contract today, it is very unlikely that the coronavirus would be considered as a force majeure because you knew of it when you entered into the contract. As I identified before, whilst there are a lot of relevant events entitling a contractor to an extension of time, there are less relevant matters because, as I've identified, certain of the events are considered as being neutral events for which the contractor is not entitled to loss and expense. Right, dealing with differences between the NEC and the JCT. I've listed a few in the notes that hopefully Julie will be passing to you, but they are fundamentally different in the nature of events that are included and the way they are dealt with. One of the clauses that we potentially have under the NEC is the force majeure clause in effect, which is any event that neither party could have foreseen or prevent. As I pointed out, this foreseeable is particularly relevant when thinking about the coronavirus because people could have foreseen it if they're entering into a contract today. One particular event which is in the NEC but which is not in the JCT is unforeseen ground conditions. We should remember the NEC is the new engineering contract. This is an engineering form, whereas the JCT is a construction form. Now, this being an engineering form is following the similar format to the ICE forms, where the contractor can have an extension of time for unforeseen ground conditions. And when looking into unforeseen ground conditions, they'll need to consider the site information provided to the contractor at the time of contract. And if it can be shown that the ground conditions actually encountered are different, then that is a compensation event for which the contractor can claim an extension of time and additional monies as part of his assessment of the compensation events. Under the JCT, however, there is no relevant event for ground conditions. However, there may be ways that you can claim. The first way, obviously, is depending upon what information is given to you. Now, it is not uncommon under JCT forms for contractors to be issued with reports, soil investigation reports or other reports, which the contractor is meant to read and to consider when submitting their price, particularly when they're on for, say, a design and build contract. So they've just won this project. It's a design and build contract. Included within the documents that have been issued is a ground investigation report, which shows that the soil is lovely. It will cut like butter. You'll need to put in simple strips, no problems whatsoever. What then happens is you go down on site and what you find is anything but. You find obstructions and no end of other problems, all causing the nature of the ground conditions to be reviewed, and as a consequence, the design for the groundworks to be varied, with very, very deep piles needing to go in. If you can show that that ground investigation report was a contract document, then there has been a breach. The information that forms part of the contract and provided to the contractor is wrong. And the contract provides that any error of that like can be claimed as a variation and or as a breach. And as a consequence, the contractor can seek to recover for those ground conditions that were not foreseen. Now, it should be remembered, why did the employer issue this document? The reason they did it was to make the contractor price upon it and price for far simpler foundations. Now, to try and get round the issue of breach, what quite often happens is that the ground investigation report is not included as a contract document, and or within it there is a very, very bold statement that says, Mr. Contractor, do not rely upon this report. Now, the reason for that is, by so doing, the employer is in effect trying to insert an limitation of liability clause. By not including it as a contract document, they cannot be in breach. It's not a contract document. But by nevertheless issuing it to you, they have represented that the soil is as per that report. And if that report is wrong, that is a misrepresentation. And if it is a misrepresentation, there is a potential to claim damages. So by including an exclusion or a limitation clause within it, the employer is seeking to avoid liability. Now, they will not always be successful because the Unfair Contract Terms Act can come to the contractor's assistance. And what that provides is that depending upon how onerous the clause is, it must be brought to the reasonable attention of the other party. And that is why when you go, for example, in car parks, you see all these signs near the machines where you have to pay saying, we accept no responsibility for you leaving your car in this car park and it being damaged. That's an exclusion clause to make sure that it is not seen as unfair. It has to be brought to your reasonable attention. And so by putting it where you pay, you are expected to have seen it. So when dealing with an soil investigation report, that exclusion clause needs to be in big, bold writing, ideally on the front page so the contractor does not miss it. If, however, it is on the back page in very small writing, there is every chance that it will be considered as not being brought to the reasonable attention of the contractor, and as a consequence, the contractor can nevertheless claim for damages for misrepresentation. I've already dealt with adverse weather conditions a little earlier on, and what I identified that unlike the JCT, under the NEC, we can claim both money and time. Under the JCT, we can only claim time. Now, as far as the NEC is concerned, what we have is a weather measurement to be taken. And what you have to look at is to see that whether the weather you've anticipated or you've incurred at the present time occurs less frequently than once in every 10 years. So we've got a very much a prescribed manner by which we can determine whether the weather is adverse. Under the JCT, whilst it is not stipulated that you have to look at past years' reports, that's the way you would generally go about it. Because in establishing it is exceptional, you need to show that it doesn't happen all the time. And generally, 10 years of reports to show that it doesn't happen all the time is a reasonable way of showing it. Now, the next thing is under the JCT, we have the word adverse. This would not necessarily mean poor weather. It could mean extremely hot weather. I'm quite old. I remember back to a year where we had a tremendous summer, and I was on a construction site where we were doing new roofs. And as a consequence, we had to put up temporary roofs with all plastic sheeting. And because the weather was just so hot, it was like working in a greenhouse. And as a consequence of that, those that were working on the roof could only do so many hours a day. We had to bring them out and actually shower them down and give them water. And we claimed an extension of time because of extremely good weather, and were successful. And indeed, the term adverse was brought in, if my memory serves me right, in 1972 after the exceptionally good weather of 71. Now, the next thing is, under a JCT, we've proved it's exceptional, we've shown that it's adverse. What we then need to do is to prove what the delay is caused as a consequence. Now, it isn't always the case that the weather is actually causing a problem. If you've got tremendous rain, but you're working on an internal project, it may not be affecting the works at all. Equally, we may only have 1 day worth of weather, but it could have far more implications. Let's just say the weather is hurricanes, terrible winds, which damages a major crane on site, which therefore causes a delay way beyond the simple day. So under JCT, we have a number of steps to take. We have to first show that the weather is exceptional. We have to show that it actually impacts upon the works. And we then have to show what is the actual delay caused to completion. NEC is different. NEC is we simply show what the weather conditions are. We compare it with what are those conditions for the last 10 years. And if it is greater, that is a compensation element, as a matter of fact. We then put in our quotation as to what is the effect of that compensation event, both time and money, and provided that's reasonable, then the PM ought to accept it. You can see that under the NEC, the implication or the assessment of a compensation event for weather conditions ought to be far more simple. Unfortunately, in my experience, it is anything but, because quite often parties do not accept or do not submit the programs or the compensation events in due time, and or even if they are submitted, the PM quite often doesn't accept it. And I will be coming back to that point a little later. One thing that is very important and to stress under the NEC and in comparison to the JCT is the notification requirements. Now, under JCT, if there is a variation, you don't have to notify the architect, the contract administrator, there's a variation. There's no obligation. They issue an instruction, you implement it, and you evaluate it as a variation. If, however, you think it is a relevant event, you have an obligation to issue a notice within a reasonable period of time. The question therefore flows from this is the issue of a notice of extension of time under JCT a condition precedent to entitlement? The word or the phrase condition precedent means that if you do not issue the notice, you lose your entitlement. Now, under the JCT, it is not a condition precedent that you issue a notice of extension of time for a relevant event. And I can say that very clearly because the JCT contract provides that 12 weeks after practical completion, whether or not the contractor has submitted an extension of time notice, the contract administrator shall nevertheless consider what entitlements to extension of time the contractor has. So in other words, even where the contractor does not issue a notice of extension of time, they will nevertheless be entitled to an extension of time if it can be shown they have such an entitlement 12 weeks following PC. So why issue notices? Well, the simple fact is if you issue a notice of extension of time, the contract administrator is obliged to consider that extension of time notice within a period of 12 weeks from receipt of the notice, or where the date for completion is less than 12 weeks, by the date or set for completion. So in other words, the contractor can seek to get an extension of time far, far quicker. But the fact that they have not sought an extension of time does not prevent their entitlement. But what about loss and expense? Is a notice of loss and expense a condition precedent to an entitlement to loss and expense under JCT? And the answer is yes. Under the JCT, if you look at the clause dealing with loss and expense, it all flows from the contractor having first issued the relevant notice. It does not say 12 weeks after PC, the contract administrator will consider whether they've got an entitlement. There is no such clause. So, absent the issue of a notice requesting loss and expense, the contractor loses their entitlement. I should add, however, that the JCT preserves your common law rights, and that would include a claim for damages for breach of contract. So whilst the contractor may not be able to recover loss and expense, they may recover damages for breach of contract, which raises the question, what's the difference between loss and expense and damages? Well, the starting point is that loss and expense is to be determined and assessed by the contract administrator with the assistance of the QS. And there is a mechanism in the contract for its payment throughout the process. By contrast, damages is a claim through potentially adjudication, arbitration, or litigation. It's much more difficult, and therefore it is far more beneficial to claim loss and expense under the contract than damages for breach. Indeed, the courts, when considering claims for damages, will award a contractor less money than loss and expense under the provisions of the contract because of their failure to comply with the contractual mechanism. I should further add that a failure to issue notices, be it a notice of extension of time or a notice of loss and expense, is a breach. And if it can be shown that those failures have prevented the employer project manager from reducing the likely cost, then the contractor's entitlement will be similarly reduced. Under NEC, however, and those of you who will be aware, there is a huge amount of paperwork that is required to be issued. So let's just get a very simple one. Let's just say that the project manager issues an instruction. If such an instruction is issued, the project manager at the same time, but issued separately, should issue a compensation event notice. So they should say the issue of this instruction is a compensation event because it may cause delay or it may cause an increase in the prices. So we've got two so far. We've got an instruction and we've got a compensation event notice. Project manager also should issue an early warning notice. Project manager is obliged to issue an early warning notice where there is an event which is likely to cause delay or increase the cost of the prices, or is to affect the works as undertaken. So clearly that is a possibility as a result of an instruction being issued. So they should issue three notices. They should issue the instruction, compensation event notice, and an early warning notice. They should issue a fourth, actually, because they should also be issuing an instruction or a request for the contractor to submit a quotation. Now, it is my experience that quite often that does not happen. Where that does not happen, the obligation to issue the early warning notice and the compensation event notice falls upon the contractor. And it says that the contractor is obliged within 8 weeks of becoming aware of the occurrence that he must issue a compensation event notice. And where he fails to do so, he loses his entitlement. So I must impress upon you the importance of issuing an early warning notice and a compensation event notice. I should add that it also says, with regards to the issue of an early warning notice, that where the contractor has not issued an early warning notice, it will be treated as if he has, which is a rather strange wording. I've shortened it, but what it's basically saying is if you don't issue an early warning notice, if we determine that if you had, we would have saved a week's worth of delay, then the assessment of the compensation event would involve reducing the entitlement by that 1 week. So under the NEC, the contractor is obliged to issue, where the PM has not, an early warning notice and a compensation event notice. Once that's been issued and the employer PM has requested, the contractor would then submit his quotation together with a programme where he is of the view that the works are likely to be delayed. So the question arises, what happens if, and let's be honest, it all too often does happen, that the contractor does not issue an early warning notice within 8 weeks of becoming aware? And I'm going to refer you to this case, Northern Ireland Housing Executive versus Healthy Buildings Ireland Limited. A very, very good adjudicator was appointed. It was me. And what happened was that there was a requirement for Healthy Buildings Ireland to do certain asbestos surveys. And this whole requirement arose because of discussions that were held during a meeting and which were recorded. And unfortunately, the contractor did not issue a compensation event notice. And on such premise, it was argued by the employer that the contractor had lost their entitlement. I, however, did not agree with the employer because it was my view that the PM had an obligation himself to issue a compensation event notice, because the contract is very clear. Where the PM issues an instruction, he is also obliged to issue a compensation event notice. And because he had failed, the 8-week requirement fell away. Unfortunately, the housing executive did not agree with my decision, and they went off to the courts. And as I understand it, I think there was at least 2 court cases, but both of them found that my decision was right. That effectively, because the PM had an obligation to issue a compensation event notice, the 8-week restriction or the 8-week requirement to notice fell away. However, what I would strongly urge you to do is to ensure that you do issue compensation event notice, because the argument of why this did not fail in the Healthy Buildings case is because the PM had an obligation to issue compensation event notice. For such events as weather, there is no obligation upon the PM to issue such an compensation event notice. It only arises because it expressly states that if he issues an instruction, he must also issue a compensation event notice. He's not issuing an instruction with regards to weather. He's not issuing anything. So there is no obligation upon the PM to issue a notice. So the obligation falls purely on the contractor, and he's got 8 weeks from him becoming aware. There are other events that would similarly apply. For example, access. If you're not getting access by the date stated on your accepted program, contractors have an obligation to notify within 8 weeks. One final thing I want to deal with is the fundamental difference between the way things are assessed in theory under the NEC when compared with the JCT. For those of you who are working under the NEC, you will be aware that extensions of time are assessed as the difference between the date of the last accepted program and the current accepted program. So to give you an example, I enter into a contract under the NEC, and I put in my contract, or in the contract, it provides that I have to complete within 50 weeks. I decide as the contractor that it is perfectly feasible for me to finish within 40 weeks. And I produce a fully detailed program for acceptance showing me myself finishing within 40 weeks. Unless there is a bespoke amendment, the PM is obliged to consider my program and accept it. If I then am delayed by an extra 10 weeks and finished within the 50 weeks prescribed under the contract, it is the difference between my current program and the new program being 10 weeks, and hence I'm entitled to an 10-week extension of time and the costs associated with 10 weeks, even though I finished on time. Under the JCT, it is a delay caused to the completion date. It has got nothing to do with the program. So following Glenlyon versus the Guinness Trust, under the same circumstances, the contractor would be entitled to no extension of time and no loss in expense. And what we're identifying is fundamental differences about both the ways extensions of time and loss and expense are dealt with under the two forms. I will go further. On the loss and expense, it is your actual loss that you have an entitlement to recover under JCT. You have to prove it. You can't prorata your prelims. You've actually got to show what the actual losses you've incurred are. Under the NEC, it is a forecast of what you anticipate will be your costs, based upon normally the schedule of cost components. It's got nothing to do with what your actual loss will be. It will be what you've reasonably forecast. Unfortunately, it is my experience more often than not that compensation events are not agreed in accordance with the contract, and they are considered retrospectively. And on that, it is another case that I was involved in as adjudicator, where I was decided, and it was equally considered to be correct by the court, that where you have the correct information, you should not be doing a retrospective analysis. You should be basing it upon what you know to be true. So, in summary to what I've said, be warned, the JCT is nothing like the NEC. The NEC requires a huge amount of additional management time, both for the contractor and for the project manager. If you're going to be a contract administrator, your workload is going to be significantly less than what would be a project manager under the NEC. Hope that's been useful. Julie, are there any questions?
There are indeed. Someone's asking here, does it state in the NEC that there is no common law right to any changes outside the compensation event list? Are there many other common law rights removed under the NEC?
The answer is yes and no. It does not expressly say that your common law rights are excluded. It actually says that your rights are effectively for compensation events is your only right. And thereby implication, your common law rights are excluded. So very simply, your only right to recover for more time or additional cost is through the compensation mechanism, and you cannot claim under the common law at all.
Okay, under an NEC contract whereby the contractor has been denied access to site and both parties subsequently agree a revised and resequenced mobilisation, how should the contractor quote prospectively?
Well, that's quite a long question. The starting point is that what should happen is there should be a programme which has been accepted which shows the date for access. And let's make our lives easier. Let's just say that the date for access shown on the programme matches the date for access stated in the contract data. What then happens is there is a statement to the effect that you will not get access. So on that basis, contractor should issue an early warning notice compensation event notice. Project manager should then agree and therefore should request a quotation for the compensation event. There then may well be an early warning meeting, which the parties all sit down and discuss ways of overcoming the problem. And as part of that process, I am guessing they've come to a conclusion of a revised plan, which is what is being referred to by the person answering the question. The contractor then's got to be very careful because they cannot make any assumptions in their compensation event quotation, because if they make an assumption, they're priced for it, even if it proves to be wrong. So what the contractor should say, therefore, is we will price this, but we would ask you as the PM to state what assumptions we should take. They then submit that quotation based upon that assumption, and indeed it could be as part of the quotation for a submission of acceleration. On that proviso, therefore it's all been priced, hopefully agreed. If then access is not given by that date, there then is another compensation event. So that's the way of dealing with it. Make sure that you've got clearly stipulated in PM's instruction what assumptions are to be taken. For example, you shall assume that you'll get access on this date, assume X, Y, and Z, and thereby allowing the contractor to price fully and clearly, including all their risks, as part of their quotation and including a program. And then if it proves not to be the case, which again, unfortunately, my experience is all too often the case, they can then pick it up as another compensation event.
Okay. Is the client at a disadvantage where they fail to respond to a compensation event as required by the contract, then subsequently reaches an agreement with the contractor on how to deal with the compensation event?
Okay, under the NEC, there is a provision for the contractor to submit quotations. There then is a requirement for the project manager to come back within a set period of time, either accepting the compensation event or rejecting it. And where rejecting it, there's a number of bullet points on what basis he can then reject it. If he's rejecting it, he can ask the contractor to resubmit his quotation, or he can remove the instruction so it is no longer a compensation event, or he can stipulate that he will basically assess the compensation event. If the project manager fails to respond at all, the contractor can then issue what is in effect a warning notice. He says to the project manager, you have failed to respond to my compensation event quotation within the required period of time. If you continue to fail to respond within a set period of time, it is then deemed you've accepted it. So the client stroke project manager could be at risk where that procedure has been followed. But what you're indicating to me is that a quotation has been submitted but not been accepted, and then subsequently the parties have agreed a revised approach of dealing with it. There therefore should be another quotation submitted which can be accepted and no problem is caused. But under the strict wording of the NEC, by failing to respond, that in itself is a compensation event. So they ought to really be responding.
Okay, and then there's a final question here. In your opinion, what is the better contract?
Am I selling or buying? The answer to that is, sorry JCT, sorry NEC, I don't like either of them. And why do I not like either of them? Because they never exactly match what is the project. There are general contracts. And the NEC, quite rightly, I think, includes Z clauses. And the Z clauses enables a party to develop and amend that contract to reflect the actual contract. So it is my view that on all contracts, you should amend them. So the NEC is more flexible and I like that. But equally, I find that NEC is not fully understood. It is not fully followed. And that quite often parties say, oh, well, we agreed everything. Yeah, but it was part of a global settlement agreement. You didn't follow it. And I find the biggest disputes are generally under the NEC. As far as the JCT is concerned, I think people have a far greater understanding of how it works. And I think it is an ability of reducing the management input. So I think in choosing the appropriate form, you need to decide which one is best suited for the works that you're undertaking. If you're a local authority carrying out certain works where your amount of management time is limited, I wouldn't use the NEC. Equally, if you're looking to build Wembley again, I think NEC would be a very good contract, but you need to amend accordingly. I hasten to add, I have, a few years ago, built my own house. And I decided which format suited me perfectly. And that was the JCT design and build. And what I did was I fully designed the works. I then made the contractor responsible for that design and left it with them. Very simple. I would not have used the NEC.
Okay. Another question here. Under JCT, is there an express provision that common law rights for changes are entitled, or does the JCT simply not limit them?
No, what it says in the JCT is your common law rights are preserved, and therefore any delay caused by an event and in theory lost expense can nevertheless be claimed if for any reason your contractual right falls away. Now let's start. The contract clearly provides for instructions and variations, and even if you miss them, you can pick them up later on. So generally, where are you going to be looking for your common law rights? It is because of delay. And you're going to be looking for your common law rights by reason of loss and expense because you haven't necessarily issued your notices. So most common law rights will be claimed by contractors for extensions of time. And equally for employing parties, it will be claims for damages for breach for late completion, where, for example, time has been rendered at large.
Right. So does the NEC limit your common law rights anywhere else
There are no
other than
common law rights under the NEC at all. They are removed.
Perfect. Okay, well, that's all the questions answered. So thank you very much, Richard. Thank you to everyone for attending this evening. Recording of this seminar will be up on our YouTube channel tomorrow. But as we said earlier, if you have any queries directly for Richard, please feel free to email him, richardsilver@silverllp.com. Thank you, Richard. Thank you, everyone, and good night.
Good night, all.